Good day everyone, we are the Group 1 and today we'll be discussing the revised Corporation Code of the Philippines, specifically titles 1 to 4. In this discussion, you will learn about the general provisions of the Corporation Code, including how corporations are formed and who the incorporators and members are, and the different types and classifications of corporations under Philippine law. We'll also cover the powers, rights, and responsibilities of corporations, as well as the basic legal principles that govern their operations and organization. Through this topic, we aim to give you a clear overview of how corporations are structured and managed, and how the law measures their proper regulations and accountability in the business world. With this discussion, we hope you will gain knowledge and a better understanding of the construction and operation of corporations here in the Philippines. Thank you, and let's begin. Good day everyone. Let's start with Section 1. Section 1, Title of the Code. This section gives the official name of the law, which is the Revised Corporation Code of the Philippines. It replaced the old Corporation Code of 1980 to make the law more updated, digitalized, and business-friendly. In short, whenever we talk about corporations in the Philippines today, we're referring to the Revised Code, Republic Act No. 11-232. For example, when citing the law in reports or legal documents, we say, under Revised Corporation Code of the Philippines. Section 2. Corporation defined. Section 2 define what a corporation is. It says that a corporation is an artificial being created by operation of law. That means a corporation is not a natural person like us. It only exists because the law allows it to. It has its own legal identity, separate from its owners. It can enter contracts, own properties, borrow money, and even sue or be sued. Also, it has the rights of succession, meaning it continues to exist even if the owner, directors, or members change. For example, Jollibee Foods Corporation continues to exist even if its founders retire or pass away, because this company remains because it's a legal entity created by law. Section 3. Classes of corporations. Section 3 talks about the two classes of corporations, stock and non-stock. A stock corporation has a capital divided into shares. People who invest in it are called shareholders or stockholders. They can receive dividends, which are portions of the company's profit. For example of stock corporation, Jollibee Foods Corporation is a Philippine-based stock corporation because it issues shares of stock to its owners or shareholders. The shareholders invest money in exchange for ownership shares, and they receive dividends when the company earns profits. It also registered with the Securities and Exchange Commission and traded on the Philippine Stock Exchange. On the other hand, a non-stock corporation has no shares and no shareholders. Instead, it has members, and whatever income it earns is used for its purpose, not for personal profit. Non-stock corporations are usually non-profit organization. For example of non-stock corporation is the Philippine Red Cross is a non-stock corporation because it does not issue shares of stock and has no shareholders. Instead of earning profits for owners, it uses its resources to serve humanitarian purposes such as disaster relief, blood donation, and health service. Any income it earns is reinvested to support its mission and programs, not distributed as individuals. Let's now proceed in Section 4, Corporations created by special laws or charters. This section refers to corporations that are created by special law or charters, meaning they are established by the government, not by private individuals. These corporations follow their own specific laws or charters that outline how they are managed. However, if something isn't covered in their special law, they can still follow the provisions of this code. For example, Bangko Sentral ng Pilipinas or BSP, created by Republic Act No. 7653, also known as the New Central Bank Act, Government Service Insurance System or GSIS, created by Commonwealth Act No. 186. Additional note that these types of corporations usually serve public functions and are owned or controlled by the government. Section 5. Corporators and incorporators, stockholders, and members. Section 5 of the Revised Corporation Code of the Philippines defines that the people who form and make up a corporation. It explains four important terms: incorporators, stockholders, and members. Let's break them one by one. Corporators. These are the persons who compose a corporation, whether it is stock or non-stock. They are basically the people who come together to form or run a corporation. In short, all stockholders or members are corporators. Incorporators. These are the original corporators who signed and filed the article of incorporation with the SEC. They are founders or organizers of the corporation. A corporation must have at least 2 incorporators and not more than 15 under the current law. In short, all incorporators are corporators, but not all corporators are incorporators. Once added by share or join later, they become corporators but not incorporators. Stockholders. These are the owners of shares of stock in a stock corporation. They invest money or property and in return receive stock or shares. Stockholders have ownership rights such as voting, receiving dividends, and sharing in profits. Members. These are the persons who compose a non-stock corporation. Instead of owning shares, they contribute services or participation. Non-stock corporations are usually for non-profit purposes. In simple terms, corporators is everyone in the corporation. Incorporators is the founders who started it. Stockholders is the owner of shares and in a profit corporation. And lastly, members is the participants in a non-profit corporation.
So now, let's proceed in section 6. This section says that every corporation has to write in its article of incorporation what kinds or classes of shares it will issue. This includes the rights, privilege, restrictions, and the par value if there is any. Normally, all shares are equal, but they can be different if this is written in the articles or shown on the stock certificate. A corporation may have different classes or series of shares. For example, it can have common shares and preferred shares. Common shares usually have full voting rights, while preferred shares like redeemable preferred shares may have limited or even no voting rights. But the company must always at least have one classes of shares that has full voting rights. This makes sure that the shareholders can decide on major matters in the corporation. Even if someone owns non-voting shares, they will still get to vote on important issues. These issues include changing the articles of incorporation or the bylaws, selling almost all the company's assets, merging with another corporation, increasing the company's capital, investing in another business, or dissolving the corporation. These rules protect all shareholders when big decisions are made. Shares can have a par value or they can be no par value shares. But some corporations are not allowed to issue no par value shares. Example include banks, insurance companies, public utilities, and companies that raise money from the public. If a company does issue no par value shares, each one must be sold for at least 5 pesos, and the money collected becomes part of the capital, and not something that can be given out as a dividends. Preferred shares can also have special rights or preferences. For examples, they might receive dividends first before common shareholders, or they might get priority in receiving company's asset if the corporation shuts down. These preferred shares must always have a par value, and their terms can be set by the board of directors, as long as these terms are submitted to the SEC for approval. And at last, a corporation can classify shares to follow certain laws. For example, some businesses in the Philippines must be owned mostly by Filipinos. So the corporation might create a class of shares that only Filipino citizens can own. Now we move to types of shares and their special rules. First is Section 7, about founder shares. These are shares given to certain shareholders called founders. Founders can be given special rights and privilege that other shareholders do not have. For example, they may be given the exclusive right to vote and even be voted for when choosing the company's directors. But this special voting right can only last for 5 years from the date the corporation is formed. Also, these rights cannot be used if they violate laws that protect Filipino ownerships, such as the Anti-Dummy Law or the Foreign Investment Act. So even founders' rights must still follow national rules on control and ownerships. A simple example, if a company is an industry that must be 60% Filipino-owned, founder shares cannot be used to secretly give control to foreign owners. Next is Section 8. Talks about redeemable shares. Corporation can issue redeemable shares, but only if this is clearly written in the Articles of Incorporation. These are special shares that the company can buy back from the shareholder after a certain time or under certain term. For example, the articles might say the company can redeem the shares after 5 years at a set price. The company is allowed to redeem these shares even if does not have unrestricted retained earnings as long as everything follows the terms in the articles and the stock certificate. And the process follows SEC's rule. And lastly, Section 9, which explains the treasury shares. These are shares that were already issued and fully paid for, but the corporation later got them back. This can happen through purchase, redemption, donation, or other legal ways. Treasury shares are no longer could be part of the company's outstanding shares, meaning they do not have voting rights or dividend rights. However, the company can sell or reuse these shares again later at a price the board of directors considers reasonable. For example, if the market slows down and the price drops, the board may hold the treasury shares for a while, then reissue them later when conditions improve. And that is all for our Title 1. Now we can proceed to Title 2.
Title 2, Section 10 of the Revised Corporation Code of the Philippines addresses the number and qualifications of incorporators. It states that any person, partnership, association, or corporation can organize a corporation, either singly or jointly. If you are a natural person, you must be of a legal age to organize a corporation. and may fall under the category of an OPC or one-person corporation. If the organization is joint, it must not exceed 15 individuals or members. Now, let us define an OPC or one-person corporation. An OPC or one-person corporation is composed of only one stockholders, and only a natural person, trust, or estate can incorporate as one. Now let us differentiate the incorporators versus corporator. Incorporators are the people who starts the company, their name in the first official papers, while corporators are anyone who is a member or stockholders of the company, whether they started it or joined later. And we have three steps in creating the corporation. For example, if you're starting a business with your best friend, you'll go through promotion, incorporation, and formal organization. Here's the breakdown. Promotion. As a promoter, you brainstorm ideas, plan, and organize your business concept. This is the initial stage where you're developing and refining your business idea. Next is incorporation. This is where you make it official. You file, sign, and register with the SEC or Securities and Exchange Commission. And lastly, the formal organization. This is where the business truly starts operating. You create bylaws, which are the internal rules for how the company will be run. You elect a board of directors and officers to manage the company. Qualifications of incorporators. Each incorporator of a stock corporation must own or be a subscriber to at least one share of the capital stock. This means that if you and your best friends are building a business, you must have a share in the capital of your business, or what we call a subscription. This demonstrates your commitment and investment in the company. If you are an incorporator of a non-stock corporation, you are also required to be a member of the corporation. You cannot be an incorporator without also being a member. Designation of incorporation as directors or trustees. An individual signing the articles of incorporator or incorporation as a representative of a company cannot be named as a director or trustees of the new corporation unless that individual also personally owns at least one share of stock or is a member of the corporation being formed. And lastly, the additional requirements for a certain corporation. Certain corporations such as banks, insurance companies, and other financial intermediaries requires a favorable recommendation from the appropriate government agency to ensure their articles of incorporation comply with the law before they can be approved. Now let us now proceed in Section 11 of the Revised Corporation Code of the Philippines. It states that a corporation lifespan or corporate term is generally perpetual unless its articles of incorporation specify a limited duration. This term can be altered through amendments to the articles, provided that such changes are not made within 3 years of the term's expiration without justifiable reasons. So, who may apply for revival? Corporation is eligible to file petition for revival of corporate existence include those whose term has expired, those who revoke certificates of registration due to non-filing of reports, those with suspended certificates of registration, and those whose corporate name has been reused, and who may not apply for revival. Corporation restricted from filing a petition for revival include those that have completed asset liquidation, those who revoke certificates of registration for reasons beyond non-filing of reports, those dissolved under specific sections of Presidential Decree number 902-A as amended, and those that have already registered as Memorandum Circle number 13 or series of 2019 or related SAC circulars unless the re-registered corporation consents to the petition's use of the corporate name and commits to either voluntarily dissolution or a name change upon the petition's revival. And what is the required vote to initiate revival? To initiate the revival of an expired corporation, a majority vote is required both from the board of directors or trustees of non-stock corporations and from the holders of the outstanding capital stocks or member for non-stock corporation, ensuring support from the leadership and ownership of the revival process. And now let us now proceed in section 12. That is generally stock corporations don't need a minimum capital to operate, but exceptions exist where a special law mandates a minimum capital for specific types of non-stock corporation. And let's proceed in section 13 of the revised corporation code of the Philippines. It mandates that all corporations in the Philippines file articles of incorporation with the SEC, which can be in any official language and now filed electronically.
Section 14 Form of Articles of Incorporation. Unless otherwise prescribed by special law, the Articles of Incorporation of all domestic corporations shall comply substantially with the following form. The undersigned incorporation, all of legal age, have voluntarily agreed to form a corporation under the laws of the Republic of the Philippines and certainty the following. First, that the name of said corporation shall be blank Inc. Corporation or OPC. Second, that the purposes for which such corporation is incorporated are, if there is more than one purpose, indicate primary and secondary purposes. Third, that the principal office of the corporation is located in the city or municipality of blank province of blank Philippines. Fourth, that the corporation shall have perpetual existence or a term of 4 years from the date of issuance or the certificate of incorporation. Fifth, that the names of nationalities and residence addresses of the incorporators of the corporations are as follows. Name, nationality, residence. Six, that the number if directors or trustees of the incorporation shall be blank and the names, nationalities, and residence addresses of the first directors or trustees of the incorporation are as follows. Name, nationality, residence. Seventh, that the authorized capital stock of the corporation is blank pesos blank divided into shares with the pair of value of blank per share. In case all the shares are without pair value, that the capital stock of the corporation is shares without pair value. 8. The number of shares of the authorized capital stock stated has been subscribed as follows. Modify number 8 if shares are with no par value in case the corporation is non-stacked. Number 7 and 8 of the above articles may be modified accordingly, and if it's sufficient, if the articles may be modified accordingly. And it is next month. Ninth, that Rank has been elected by the subscribers as treasurer of the corporation to act as such until after the successor is duly elected and qualified. In accordance with the bylaws, the treasurer's authority has been given to receive in the name and for the benefit of the corporation all subscriptions, contributions, or donation paid or given by the subscribers or members who certifies the information set forth in the 7th and 8th clauses above, and that the paid a portion of the subscription in cash and or properly for the behalf and credit of the corporation has been duly received. 10th, that the incorporations undertake to change the name of the corporations immediately upon receipt of notice from the commission that another corporation, partnership, or person has acquired a prior right to the use of such name, that the name has been declared as not distinguishable from a corporation or that is contrary to law, public morals, and good customs or public policy. 11th, corporations which will engage in any businesses or activity reserved for Filipino citizens shall provide the following. no transfer of stock or interest which shall reduce the ownership of Filipino citizens, and less than the required percentage of capital stock as provided by existing law shall be allowed or permitted to be recorded in the proper books of the corporation, and the restriction shall be indicated. Moving on, Section 15, Amendment of Articles and Corporations. Unless otherwise prescribed by this code or by special law, and to legitimate purposes, any provision or matter stated in the articles or incorporations may be amended by a majority vote of the board of directors or trustees and the vote of 1% of the stockholders representing at least two-thirds of the outstanding capital stock, without prejudice to the appraisal right of dissenting stockholders in accordance with the provisions of this code. The articles and corporations of the non-state corporation may be amended by the vote of written assent of majority of the trustees and at least two-thirds of the members. The original and amended articles together shall be contain all provisions required by the law to be set out in the articles of incorporation. Amendments to the articles shall be indicated by understanding the change made, and a copy thereof duty certified under oath by the corporate secretary and the majority of directors or trustees, with a statement that the amendments have been had been duly approved by the required vote of the stockholders or members. So, the amendments will take effect upon the approval by the Commission or for the date of filing with the said Commission, if not acted upon within 6 months from the date of thing for a cause not attributable to the. Section 16. Grounds when articles of incorporation are amended may be disapproved. The Commission may disapprove the articles of incorporation or any amendment thereto if the same is not compliant with the requirements of the code, provided that the Commission shall give the incorporation directors, trustees, or officers a reasonable time from receipt of the approval, when which to modify the objectionable portions of the articles or amendment. The following are ground for such disapproval. A. First, the articles of incorporation or any amendment thereto is not substantially in accordance with the form prescribed herein. Second, the purposes of the corporation are patently unconstitutional, illegal, immoral, or contrary to government rules and regulations. Third, the certification concerning the amount of capital tax subscribed and or paid is false. And fourth, the required percentage of Filipino ownership. Next, Section 17. Corporation name. No corporation name shall be allowed by the Commission if it is not distinguishable from that already reserved or registered for the use of another corporation, or if such name is already protected by law, rules, and regulations. A name is not distinguishable, even if it contains one or more of the following: A. Refers corporation, company, incorporated, limited, limited liability, or an abbreviation with such words and punctuations, articles, conjunction, contractions, preposition, abbreviations, different tenses, spacing or number of the same word or phrase. The Commission, upon determination that the corporate name is One, not distinguishable from name already reserved or registered for the use of another corporation. Second, already protected by law. Third, and this contrary to law, rules and regulation may summary order the corporations to immediately cease and desist from using such name and require the corporation to register a new one. The Commission shall also cause the removal of all visible signages, marks, advertisements, assets, prints, and other effects bearing such corporation name upon the approval of the new corporate name. The Commission shall issue a certificate of incorporation under the amended name. If the corporation fails to comply with the Commission's order, the Commissions may hold the corporation and its responsible directors or officers in contempt and or hold them administratively, civilly, and or criminally liable under this code and other applicable laws.
Move forward to the last four sections of Title II, Sections 18 to 21. To form a corporation, an individual or group of persons must first submit the proposed corporate name to the Commission. The Commission will verify that the name is original, legitimate, and unregistered. Following approval, the name is reserved for the incorporators, who subsequently submit their articles of incorporation and bylaws. The Commission then issues a certificate of incorporation if the documents meet all the legal requirements. The certificate gives the corporation its juridical personality, hence it is important. Unless it is extended or dissolved earlier, according to the law, the corporation is legally created from the date of issuance, has the power to enter into contracts, own property, sue or be sued, and continued for the period stated in its articles. Section 19. De facto corporations. A group sometimes may honestly believe it is a corporation and commence operations despite a minor defect in registration. In such cases, private lawsuits are not allowed to challenge the corporation's authority to exercise corporate powers. Only by bringing a quo warranto action may the government, through the Solicitor General, question the corporation's status. By doing this, people who deal with the corporation in good faith are protected from being harmed. To qualify as a de facto corporation, three conditions must be met. First, the existence of a valid law under which it may be incorporated. Second, an attempt in good faith to incorporate. And third, assumption of corporate powers. The issue of a certificate of incorporation and the filing of articles of incorporation are necessary. The Supreme Court has made it clear that a group not registered with the Securities and Exchange Commission cannot be regarded as a company at all, not even a de facto one. Two public interests are balanced by the de facto doctrine. First, keeping unauthorized individuals from taking advantage of corporate benefits and ensuring justice and safety for individuals doing business with companies in good faith. This doctrine protects the general public who depends on the corporation's status. For example, incorporation papers for XYZ Incorporation were submitted by a group of persons to the SEC, but a minor error happened, which delayed its approval. The corporation started operating the business, entering into contracts, and hiring employees. Result: the court may treat XYZ Incorporation as a de facto corporation because the attempt to incorporate was made in good faith. Section 20. Corporation by a stoker. When a group acts as a corporation without authorization, it is directly responsible for any debts, damages, or obligations that arise from such acts, just like general partners who are personally liable. However, the corporation cannot claim it does not legally exist in order to escape its responsibilities if a third party deals with it in good faith. Likewise, anyone who assumes duties with an ostensible corporation is obligated to perform them, even if the corporation is not legally incorporated. This doctrine guarantees fairness in business transactions and prevents parties from evading responsibility by hiding behind a false corporate identity. The doctrine applies in two ways. First, in opposition to the ostensible corporation. In the event that the third party files a lawsuit against an unincorporated association that represents itself as a corporation, the group cannot deny its corporate status. Lack of legal personality cannot be used as a defense to avoid accountability for contracts or advantages it received. Second, against third parties. A third party who treated the group as a corporation and received benefits despite knowing it was unincorporated may be barred from denying its corporate existence in a lawsuit. People who benefited from the ostensible corporation's operations, notwithstanding the fact that they know it was not legally registered, may be held liable for the contracts and obligations they implicitly accepted. For example, no papers were filed, but a certain group calls itself XYZ Incorporation. The group entered into contracts with suppliers and clients who in good faith believed XYZ was a legitimate corporation. However, the persons originally involved tried to avoid liabilities by saying that they are not legally incorporated. Result: courts hold the person involved personally liable because they represented themselves as a corporation. Last section for Title 2, Section 21, Effects of Non-Use of Corporate Charter and Continuous in Operation. A corporation that does not formally organize and commence operations within 5 years of incorporation will have its certificate of incorporation automatically revoked the day after the 5-year period. Another is when a corporation has begun operating but ceases to do so for at least 5 consecutive years, the Commission may declare it delinquent after providing notice and holding a hearing. Yet a delinquent corporation has 2 years to resume operations and satisfy all SEC requirements. If it fails to do so, its certificate of incorporation is revoked or cancelled. Before officially suspending or revoking corporations under their special jurisdiction, the Commission must also notify and coordinate with other relevant regulatory agencies to ensure fairness.
Good day everyone, my name is Joshua Magalong, and my report focuses on the Title 3 of the Code, the Board of Directors, Trustee, and Officers. Firstly is the Section 22 of the Title 3, which is basically defines who runs the company and for how long. First is the Director is elected for a single 1-year term. Also to the Director, you have to be a stockholder, owning at least 1 share of stock. Stop owning that share, you stop being a director. On the other hand, trustee term is longer. A trustee can serve not exceeding 3 years. Non-stock organization often prefer this longer term because it gives them more stability and continuity. The law created a special rule for companies that affect the public a lot, called corporation vested with public interest. If a company is considered public interest, like banks or insurance company, registered under the Secretary Regulation Code, they must have independent directors on their board. And an independent director is basically a neutral party, someone with no financial or business ties to the company. This rule is there to make sure important decisions are made honestly and are not just serving the interests of one major group. Now we are covering the Section 23, electing the Board of Directors or Trustees. Firstly is the right to vote is open to everyone. Every stockholders or members can suggest a qualified candidate. For the election to be valid, we need a majority quorum. That means most of the owners or member must be present. You can be present in person, proxy, or both remotely. That is counted as present. And if you own a share, you get to use the cumulative voting. This means you count your shares, multiply them by the number of open shares, and you get a total votes. And you can put it all your votes to 1 or 2 candidates if you want. And for non-stock corporation, this is more straightforward. Can only give 1 vote to 1 candidate. And the nominees who get the highest number of votes wins the election. And if a majority doesn't show vote, the meeting is simply adjourned and postponed. Now we focus on the Section 24. The first step is immediately after the directors are elected, their next duty is to choose the officers. Also, the law requires every corporation to fill 3 roles. The president is the top, the treasurer who handles all the company's money and must be a resident of the Philippines, And finally, the secretary who manage all the important legal paperwork and records. And it has the rule that they must be both Philippine citizens and residents. If a corporation deals with the public interest, meaning a lot of people rely on it, the board has a duty that they must elect a compliance officer. This person's job is to make sure the company follow all the laws and regulations. Second, when it comes to holding multiple jobs, the role is one person can hold two or more officer positions. Like for example, the same person will be the vice president and the secretary or treasurer. The only rule is that the president cannot be the secretary or the treasurer. Lastly, section 25, election report will be held within 30 days. After the election, the company secretary must submit the names, nationalities, shareholdings, and address of all the new directors and officers to the commissions. If there's a missed meeting, the corporation must report the holding and the reason for it within 30 days of the scheduled date, and set a new election date which cannot be more than 60 days. If they fail this second time, the commission steps in. Also, the commission can summarily order an election to be held. The quorum rule do not need a huge crowd. It only needs who show up that can be the leader is enough. And cessation of office is a leader or officer who leaves or like die, quit, or resign. The corporation must report this fact to the commission in writing within 7 days.
Section 26 explains the reason why a person cannot be elected as a director, trustee, or officer in a corporation. A person is disqualified if, within the last 5 years, they were found guilty of a crime that has a punishment or more than 6 years in prison, violated the Corporation Code or the Securities Regulation Code, found administratively liable for doing fraudulent acts, or found guilty by a foreign court for similar actions. Basically, this rule is meant to protect the company and its stakeholders by making sure that only people with good records and integrity can lead. The SEC or other government agencies can also add more rules to promote good corporate governance, meaning they want honest and responsible leaders in corporations. Section 27 explains how a director or trustee can be removed from office. They can be removed if 2/3 of all stockholders or members vote for it. The removal can be with or without cause. For example, if they are not performing well or lost the trust of the members. But there's one important reminder. A person cannot be removed without cause if it will take away the minority stockholders' right to representation. The removal must happen during a regular meeting or a special meeting that was announced beforehand. If the secretary refuses to call the meeting, the stockholders or members themselves can organize it. The SEC also has the power to remove a director or trustee if it finds out that the person was disqualified but still got elected. This section ensures that board members remain accountable and that the company can replace those who are unfit to serve. Section 28 talks about what happens when there's a vacancy in the board. For example, when a member resigns, dies, or becomes disqualified. If there's still a quorum, meaning enough members to make decisions, the remaining directors can vote to fill the vacancy. But if there's no quorum, then the stockholder or members must hold a meeting to elect a new one. If a director term ends, the election to replace them must happen on or before the term expirations. If the vacancy is due to removal, the election can happen on the same day as the removal meeting. Any vacancy must be filed within 45 days after it happens. There's also something called an emergency board. This is when an urgent situation happens and there aren't enough directors to make decisions. In that case, the remaining directors can temporarily choose officers to act as the directors to prevent serious damage to the company. But this is only temporary, and the SEC must be informed within 3 days after forming the emergency board. This section basically ensures that the corporation will still continue to function smoothly even if a director suddenly leaves. Section 29 discusses how directors or trustees are compensated for pay. Normally, if it's not written in the bylaws, directors don't get a salary. Only reasonable per diems, which means payment or indemnities. However, they can receive additional compensation if it's approved by the majority of stockholders or members. But there's a limit. Their total yearly pay must not go over 10% of the corporation's net income before tax from the previous year. Also, directors cannot vote for their own pay to avoid conflict of interest. For corporations that are considered publicly important, like big companies or those listed in the stock exchange, they must report every year the total pay of each director or trustee to the shareholders and the SEC. This promotes transparency and makes sure that no one is abusing their position for personal gain. These sections help maintain honesty, fairness, and accountability inside corporations.
Negligence or use their position for personal gain instead of the company's benefit. If proven guilty, they must return any profits gained and can be held liable for damages caused to the corporation or its stakeholders. Example, a director approved a fraudulent financial report to attract investors. When discovered, he must return any profit he gained and may face legal action. Dealings of directors, trustees, or officers with the corporation. This section ensures fairness when a corporation enters into a contract with its own directors, trustees, or officers. Such contracts are only valid if the following conditions are met. The director's presence or vote was not necessary for approval of the contract is fair and reasonable, if the corporation is vested with public interest, 2/3 of the board members must approve the contract, and lastly, if the contract involves an officer, it must be pre-authorized by the board. For example, a director sells office equipment to the corporation. The contract is valid if he did not vote for it, the price is fair, and the board approved it properly. Section 32. Contracts between corporations with interlocking directors. This section discusses situations where one person is a director in 2 or more corporations. Contracts between these corporations are valid as long as there is no fraud or conflict of interest. The interlocking director is not personally liable for the contract unless fraud is proven. For example, Mr. Cruz sits on the board of both Company A and Company B. They sign a supply contract. The deal is valid if it's fair and made in good faith. Section 33. Disloyalty of a director. A director must always act in the best interest of the corporation. If they use their position for personal gain or benefit, they must return all the profits earned from the act, unless the act has been ratified by 2/3 of the stockholders. For example, a director secretly starts competing business using company information. He must return the profits unless shareholders validly approve his act. Section 34. Executive Committee and other special committees. The Board of Directors may create an executive committee composed of at least 3 directors to handle specific matters. However, this committee cannot approve actions needing stockholders' approval, fill board vacancies, amend or repeal bylaws, or declare cash dividends to shareholders. For example, the executive committee may approve contracts or routine transactions but cannot decide to issue dividends or change bylaws. Those decisions belong to the full board of stockholders.
Today, I will discuss Title 4 of the Corporation Code, which is about the powers of corporations. The main idea of Title 4 is that a corporation can only exercise powers that are necessary to achieve its corporate purposes as allowed by law, its articles of incorporation, and bylaws. These provisions ensures that corporations act within their legal authority, protect stockholders and creditors, and maintain good governance. Section 35 discusses the corporate powers and capacity of a corporation. As a juridical person, a corporation can sue and be sued in its corporate name, and may have perfectal existence unless otherwise stated. It may adopt a corporate cell and amend its articles of incorporation and bylaws. A stock corporation may issue and sell shares, while non-stock corporations admit members. The corporation may acquire, lease, sell, or mortgage property, and it may also enter into partnerships, joint ventures, mergers, or consolidations with other persons or entities. It is also allowed to make donation for public welfare, charity, science, or culture. But foreign corporations are prohibited from donating to political parties or partitions activities. Additionally, a corporation may establish benefit or pension plans for its officers, directors, and employees, and it may exercise all powers necessary to carry out its local purposes. The power to sue is generally exercised by the board of directors, but when the board fails to act on a corporate wrongdoing, a stockholder may file a derivative suit on behalf of the corporation. Section 36 of the Corporation Code gives a private corporation the power to extend or shorten its corporate term, as stated in its articles of incorporation. This requires a majority vote of the board of directors or trustees and ratification by at least two-thirds of the outstanding capital stock for stock corporations or members for non-stock corporations. Written notice of the proposed actions, including the time and place of the meeting, must be sent to all stockholders or members by mail, personal delivery, or electronically if allowed. A dissenting stockholders may exercise an appraisal right when the term is extended, allowing them to withdraw and demand the fair market value of their shares. Proper notice and compliance with procedures are essential for the validity of the corporate action. Section 37 of the Corporation Code empowers a corporation to increase or decrease its capital stock and to incur or increase bonded indebtedness. Any change in capital stock requires a majority vote of the board of directors and ratification by at least two-thirds of the outstanding capital stock at a duly called stockholders meeting. Proper written notice must be sent to stockholders, and certificate detailing compliance, subscriptions, payments, and bonded indebtedness must be filed with the SEC for the change to take effect. For bonded indebtedness, similar approval requirements apply, and the bond must be registered with the SEC. The trust fund doctrine reminds us the corporate capital is a fund for creditors, and distributions are allowed only in specific cases such as reduction of capital stock, redemption of shares, or liquidations. Compliance with SEC rules, including the 25% subscription and payment requirement, ensures the validity of these corporate actions. Section 38 of the Corporation Code covers the primitive right, which is the preferential right of the stockholders to subscribe to new shares in proportion to their existing ownership, allowing them to maintain their control. Generally, all stockholders enjoy this right, unless the articles of incorporation expressly deny it. Primitive rights do not apply to shares issued to comply with public offering or minimum public ownership requirements, or in good faith for property exchange or debt payments with two-thirds stockholders' approval. The right must be exercised within the period stated in articles or bylaws. For example, in an incorporation versus C incorporation, based on Benito versus SEC. An incorporation issued 113,800 new shares to C incorporation without notifying other stockholders. The court ruled there was no violation because primitive rights apply only to new issues of shares, not an issued share from the original authorized capital stock, which the board may issue without stockholders' approval. Suits to enforce primitive rights benefit the shareholders personally, not the corporation. Section 39 of the Corporation Code governs the sale or disposition of corporate asset. A corporation may sell, lease, exchange, mortgage, pledge, or otherwise dispose of property for local consideration, subject to the Philippine Competition Act. If the transaction involves all or substantially all asset, it requires written notice to stockholders or members, approval by majority of the board, and ratification by at least two-thirds of the outstanding capital stock or members. Dissenting stockholders may exercise appraisal rights. Substantially all asset is determined by net asset value and whether the sale prevents the corporation from continuing its business. Ratification is not required if the disposition is in the regular course of business or proceeds are used for ongoing operations. Even after approval, the board may abandon the sale, provided third parties' rights are protected. Creditors' interests must not be prejudiced, as they may resent a transfer if liabilities are not assumed. Non-stock corporation without voting members may act through a majority of trustees. SEC approval is not needed for this transaction.
Section 40, Power to Acquire Own Shares. This section says that a stock corporation may buy or acquire its own shares, but only if it has enough unrestricted retained earnings to pay them off. However, the purchase must serve a legitimate corporate purpose, meaning it should be benefit the corporation, not just a certain people. There are three allowed purposes. One, to remove fractional shares that appear when stock dividends are given. Number two, to settle debts from unpaid subscriptions like buying delinquent shares during a sale. And three, to pay dissenting or withdrawing stockholders who are legally entitled to get payment for their shares. In short, a corporation can buy its own shares, but with proper funds and for a valid reason. Sections 41, Power to Invest Corporate Funds. This allows a private corporation to invest its money in another corporation, business, or any other purpose that is not main purpose. So for example, a company's main purpose is manufacturing, then it can still invest in a tech company or small cafe as long as it follows the rules. But before making such as investment, it must be approved by the board of directors and ratified by at least two-thirds of the stockholders or members. If any stockholders disagrees with the investment, they have the right to demand payment for the shares. This is called appraisal right. So, but there's an exception. If the investment is necessary to accomplish the corporation's main purpose, then there's no need for stockholder approval. Sections 42. Power to declare dividends. The board of directors may declare dividends, which is profits shared to the stockholders as long as they come from unrestricted retained earnings. Dividends can be given in money, property, or stocks. Depends on what the board of directors decides. So, however, there are some important rules. For cash dividends, if a stockholder still has paid subscriptions, the cash dividends must first go pay off that balance, including any cost. So for stock dividends, at least two-thirds of the stockholders must approve it in a meeting. Also, a corporation cannot keep surplus profits more than 1% of its paid-in capital unless one, it needs the funds for expansion or development projects. Number two, it is not allowed by loan agreements to declare dividends. Or number three, it must reserve funds for special situations like possible leases or emergencies. So basically, Section 42 ensures fairness. Profits should be distributed when possible, but with caution and legal approval. Sections 43. Power to enter into management contract. This section talks about when one corporation can manage another corporation business through a contract. For this to happen, it must be approved by the board of directors and by a majority of the stockholders. But in some cases, a higher approval or two-thirds is needed. This happens when the same people own more than one-third of corporation, or number two, when most directors in both corporation are the same persons. These rules prevent conflicts of interest and protect the manager of corporation from being abused. This law also applies to any kind of management or service agreement, like contracts to operate another company's facilities or services. However, if the contract involves natural resources like mining, oil, or energy, it must follow special laws about how long or how it can be done. Lastly, a management contract cannot last longer than 5 years per term. That means corporations must renew or review the contract after sections 44, ultra-bias acts of the corporation. This section is simple but very important. It says that a corporation cannot perform acts or use powers that are not granted by law or stated in its article of incorporation. In other words, if the action is beyond the powers given, it is called an ultra-vires act, which means beyond power. A corporation can only do what is necessary or related to the power it already has. For example, if a corporation is created to operate a school, it cannot suddenly open a restaurant business unless it is clearly allowed in its article. That ends our report on sections 1 to 44 of the Corporation Code. We hope our discussion helped you understand how corporations are created, managed, and guided by law. Thank you for listening.